My name is Samaria Dunson, and I'm the Director of the Office of Compliance and Ethics at the Alabama Department of Public Health. Today I have with me Sancha Howard, who's an Assistant General Counsel in our legal office. And I think this actually marks the first opportunity that we've had to do training together. And fortunately for you, I know you're also excited about eHIPAA log training. So we're going to go ahead and get started. The first thing that we want to discuss is the purpose behind the eHIPAA log. The purpose is so that the department can document disclosures of patient and client information. We want to make sure that we're ensuring that it's being documented correctly and that it's being acted upon in a timely manner. Before we go any further with the discussion as it relates to the eHIPAA log, I want to talk with you a little bit about the difference between routine disclosures of health information and non-routine disclosures. Routine disclosures are going to be disclosures that are made for treatment, payment, and healthcare operations. Some examples of that would be a doctor contacting you because he needs information because we're going to be treating the same patient. So that would be a disclosure for treatment. That does not go in the eHIPAA log because that is a routine disclosure. Also, disclosures that are made for payment. If Blue Cross Blue Shield contacts us because they need claims information or Medicaid, because it's a part of that payment relationship, that's going to be considered a routine disclosure, and that won't go in the eHIPAA log. The only things that will go in the eHIPAA log are non-routine disclosures. So let's discuss what those non-routine disclosures might look like. A first example of a non-routine disclosure is going to be an unauthorized release of PHI, or protected health information. This is going to be what's commonly referred to as a breach. And there's a reminder here on the slide that whenever there is a breach, you need to make sure that you're reporting that in the ARIA system, the Automated Report of Incidents and Accidents. I know everybody out there knows exactly how to fill out an ARIA at this point, but just in case you don't, make sure that you go to the adph.org website. In the top right-hand corner, you will see an opportunity for you to log in. Once you do that, you'll put in your LCMS, username, and password. And as you look down the list, you will see Automated Reports of Incidents and Accidents, or the ARIA, and you'll click on that in order to report a breach. So a breach is one example of a non-routine disclosure. Other examples would include a subpoena, or something that you would receive as a judicial process, like maybe an order that you receive to disclose patient information. The examples listed in number 3 would include information that you provide to law enforcement or national security. I haven't had the national security example come up yet, but we'll just wait and see. Things that you would disclose as it relates to emergencies when we have hurricanes or other types of natural disasters here in our state. A very common disclosure that's made has to do with abuse investigatory agencies like DHR. If somebody reports abuse and they need information from our patient records, that would be something that you would document in the eHIPAA log as a non-routine disclosure. And finally, there may be disclosures that are made as it relates to research for that example. Some additional examples of non-disclosures have to do with patient rights. When a patient asks that we limit the release of PHI, that would be something that goes in the eHIPAA log, that documentation. There's a form for that. There's also a form that a patient will use when they want to amend or correct their PHI. Those forms will go in the eHIPAA log. And then lastly, when a patient requests an accounting of their disclosures, that documentation will be placed in the eHIPAA log as well. And one thing that I want you to remember as this information is going into the eHIPAA log, we also want to make sure that we're documenting that information in the patient record. In order to create an entry into the eHIPAA log, you must first go to your Lotus Notes. All of you all who are watching this training will have access to that icon for the eHIPAA log through your Lotus Notes homepage. Once you go to your homepage, you'll click on the eHIPAA log icon, and that will take you to this next slide where it offers you an opportunity to create an entry. It actually says create a new release form. So you'll click on that button, and it'll take you to an image that looks like this slide. From that slide, you will select your county or your office, because we also have offices or bureaus within the RSA tower that may be asked to disclose information. So those counties and those offices or locations are listed in a drop-down box. Once you select the county it would automatically populate the area that your office is in. Then you will select also from a drop-down box the type of disclosure or activity that it is, and then finally the record type. Some examples of record types would be that if the information is coming from our WIC program or from our clinic setting, you'll make sure to select the correct entry there. One of the most important things, and that's why I pointed this out separately, is that you need to make sure that you mark the date open as the date that the department received the request. And an example of that would be this. If you receive a subpoena or an authorization on a Friday, the date open will be the date that you received it, which is that Friday. If you don't actually act on that request until the following Monday, you don't actually make this entry until that following Monday, you want to make sure that you still use that Friday date as the date open, because that's the date that the department receives the request. And that's important because a number of these things that you're making disclosures for have a 30-day deadline or time period, and we want to make sure that we're accurately keeping that time period in mind. So the date opened is the date that the department received the request. This next slide will show you that the area where you put in the patient's name, their CHR number, and there are some divisions that don't have CHR numbers, so if you would just input the file number. And there's also an opportunity for you to write comments or notes in a particular section. It's called the comments and dispositions. I would use that as an opportunity if there's a particularly type, like maybe quirky authorization that you want to make sure 3 months down the line, if it comes up again, you want to be able to remember what that was about. You can use that area as an opportunity to make those notes. Also, for a number of these entries, our legal office will be seeing these. So if there are some notes that you want to make to that particular entry that you want the legal office to review, you can put that information in that section labeled comments and disposition. Now, one of the really important things for having this training has to do with the next thing that you'll see on there, an opportunity to attach the actual copy of that document. That is a new feature. That's something that we have not had before and we've not trained on before. You will actually scan in, like for example, the authorization or the subpoena. You'll scan it into your computer and save it. And then you'll enter it into this eHIPAA log in quite the same way that you would enter an attachment on an email. You'll click on that icon, it'll go within your computer, you'll be able to see where you saved it, you'll double click on it, and it'll save it to that entry. What is a fantastic thing that IT has developed is that once you put that attachment in there, and save it, and you see at the bottom it says don't forget to save it. Once you save it, that information will go to Pamela Kendrick in legal, and she'll be able to see it. So if you have the ability to scan in those documents and put them into that entry, we want you to do that. We don't want you to put it in the entry and then also fax it, because that's going to create double work in our legal office, because they're not going to be able to tell the difference between things that are coming in on the eHIPAA log and things that are coming in as paper. So that is a new feature that we wanted to make sure that you all were aware of, and it keeps there from being the duplication of work by sending information to the eHIPAA log, which comes to my office, and then also to legal. On this next slide, you're going to see how your entry appears. This is really important because every individual that's accessing this system will be able to see their entry. And that was a very important feature because we wanted to create a sense of confidentiality and privacy with the eHIPAA log. As many of you all will remember, with the paper HIPAA logs that we stopped using in December of 2014, a lot of those paper documents were kept in the same area that the records were kept. So anybody who had access to the records room could see where disclosures were being made. And it became a particular issue when you're talking about making reports to DHR for abuse, especially in our smaller counties. We wanted to make sure that we provided the patients with confidentiality as it related to that. So with this eHIPAA log system, the way that it was developed is that you can see the entry that you made. There are some individuals in the area office who can see the counties, all of the entries in the counties in their area. And then here in the central office, the Office of Compliance and Ethics, as well as the Office of Program Integrity, can have a more global view and see what's going on in the entire department. So you'll always be able, though, to go back to your specific entry. Now, after you make the entry, Our legal office will have the opportunity to either approve the disclosure, which means it's okay, go ahead and send the records out. They can approve it with conditions, which means that they approve it as long as you follow the notes that they put with that entry, or they can disapprove that entry. So it's kind of self-explanatory when you say approve and disapprove. So I wanted to show you an example of what it would look like if they approved it with conditions. And this is an example of the email that you'll see if they approve it with conditions. It'll refer to the fact that there are notes that are associated with that. So, and to make it even easier for you, when our IT department developed this, they developed it so that there's an icon within the email. So you'll be able to click directly on that icon. You don't have to go back through the home page and logging in with the icon and all that to the eHIPAA log. All you have to do is click on the icon within that email, and it'll take you right back to that entry. For this particular slide, if there were some notes from legal about the conditions, they would be in that comments and disposition section. Well, now I think it just says a test for training, but that information will be there. After you make that disclosure, it's very important that you close that record out on the date that you send the records out, because again, we're looking at making sure that we capture that time period. So you want to make sure that you go back and close it out. And then finally, in the last step, you want to make sure that you save it. Because if you don't save it and you just close it out, the system is not going to recognize that that entry is closed. It's going to continue to see it as something that's going past due. And you would have done a lot of that work for naught, because we want to make sure that we're capturing it appropriately. There are some things that I know now that Sancha wants to talk with you all about as it relates to authorizations and subpoenas.
First, I'd like to go over authorizations, then I'll move on to subpoenas.
Okay.
An authorization is a written request from a patient to the health department that authorizes the department to release a patient's records. A patient can sign the authorization to release the records to themselves, or the patient can sign the authorization to release the records to a third party. The form that's commonly used at the department for authorizations is the CHR6 form. That's the form that the department has for patients to use to request their records.
Okay.
Now, there may be some instances where outside entities may provide us with an authorization that the patient signs for us to release the patient's records. When we receive those authorizations from outside entities, those authorizations are logged in to the eHIPAA log, and legal has to approve those authorizations. Legal has to review those authorizations to determine whether or not they're valid and if those records can be released. Now, I wanted to just piggyback on the timing issue that you mentioned earlier. It's really important that the authorizations are logged into the eHIPAA log on the date that they're received or very close to that time. That way, the department can act on those authorizations within 30 days. We want to timely respond to these requests that we receive. So it's important that they are logged and that we are completing these requests within 30 days.
Absolutely.
Now, for purposes of eHIPAA, it's my understanding that only authorizations to release information to third parties will be logged into eHIPAA. It's my understanding that CHR6 forms from patients to release information to the patient will not be logged into the eHIPAA log.
That's accurate. Yes. So a patient asking for information on themselves, their own records, will not go in the eHIPAA log. But if they're asking to sign the CHR6 so that maybe their aunt could pick up some records later, those third-party disclosures will go in the eHIPAA log.
And also if they're requesting information to release, in a lot of instances, to their lawyer,
right,
that will also be logged into the eHIPAA log.
Yes.
Now let's move on to subpoenas.
Okay.
A subpoena is an order from a court to release, most of the time just to release a patient's record, and it can also be for the department to appear in court.
Okay.
Now, subpoenas, it's extremely important that we are actually logging the subpoenas into the eHIPAA log on the day it's received or really, really close to the time that we receive it, because there are deadlines that are associated with subpoenas. Subpoenas have to be responded to within, most of the times it's a 30-day deadline. Mm-hmm. And there are penalties associated with failing to respond to subpoenas. Now, courts can impose fines. They can also hold a person in contempt of court for failing to respond to subpoenas. So it's very, very, very important that we are logging the information in and that we are responding to the subpoena by complying with the court's requests. Okay. Now, there are also documents known as a notice of an intent to serve subpoena, which is basically a 15-day notice to the department that a subpoena is on its way. Now, it's my understanding that once the information is entered into the eHIPAA log, the legal department will review the subpoenas to determine whether or not we will approve the request, whether or not there's additional information that we need in order to approve the request, or there are certain records under the law that are just confidential and we cannot release them even if we have a subpoena. An example would be notifiable disease records. Those records are not subject to subpoena, and we cannot release those records unless we have a written consent from the patient or unless it's a certain type of court proceeding. So, again, it's really important that the information is logged into the eHIPAA log, and legal will follow up. Pam Kendrick in the legal department, she has access to the eHIPAA log. She's going to notify me of the request, and I will do my best to timely respond to those subpoenas that we receive.
Thank you.
You're welcome.
A couple other things that we'd like to talk about relates to these types of disclosures to law enforcement. I know that we get these scenarios a lot from the county. Somebody shows up with a badge and a gun and they're asking for information, and you kind of want to comply with those individuals, so try to give them what they want. So let me explain the type of information that can be provided to a law enforcement officer. You can provide a patient's name and their address. You can also provide identifying information, like the person's about 5'7", they weigh about 120 pounds. You know, like you can say those types of things. You can say that what they're wearing. One thing that I want to make sure that we're all on the same page about is if a law enforcement officer shows up at an office or a county health department where we're serving our patients, we don't allow any of that type of activity to go on in the health department. That law enforcement officer can't go into the clinic area. They have to wait. What they have to do is wait until the individual is exiting the health department, and then they could stop that person and talk about whatever matter it is that they have that they want to talk about. But we don't allow those conversations to take place within our lobby area or within our clinic area. Now, obviously, it would be different if we're calling the police because we have somebody who's acting erratically or that we feel to be a threat. But we often have law enforcement contact us to say, hey, I'm really looking for this particular mother and this child. Can you tell me if, they have a WIC appointment coming up or anything like that? We can tell them when they have an appointment, and we can tell them the name, address, and description. What we won't tell them is other health information about that patient. We won't say, oh yeah, and by the way, they're here for STD treatment, or they're here for family planning, or when we got their blood work back, they had this particular condition. We're just giving them locating information and identifying information about the patient. As it relates to sexually transmitted diseases, we're not providing them any information about that. Now, there are instances like within the prisons and all that kind of stuff that there may be some exceptions made. All of those exceptions, though, if you receive that type of request, needs to go directly to the Office of General Counsel so that they can deal with those issues. But these two points about the sexually transmitted diseases and the psychotherapy notes, whenever you're making a disclosure, you want to make sure that the authorization either calls for you to give the sexually transmitted disease information, or the subpoena actually asks for that information. You want to try to exclude that information if it's not specifically asked for. And in all instances, we do not provide psychotherapy notes. I mean, that's just a part of the federal regulations. We don't provide psychotherapy notes to the patient, and we don't provide psychotherapy notes to others. The only entity that we will provide psychotherapy notes to is another physician that's actually treating that patient, somebody that's also in a treatment relationship. So I just wanted to remind you all about that. Now, Pam, I was going to turn to you in just a minute because I know that before, as we were preparing for this training, we really wanted to get an idea of what types of questions people really had. The only things that we find out about are things that people call us about or issues that we see, but we wanted to really gauge the pulse of what was going on within the counties and find out what questions you had. So we did ask you to send in questions that you had, and right now Pam is going to start reading some of those questions off so that we can provide you with the answers.
Do we use the old paper HIPAA log for any request for release of records?
We do not use paper HIPAA logs anymore. They are an ex-boyfriend. We are no longer together. As of December of 2014, we are strictly with the eHIPAA log. But one thing that I do want to note is with these HIPAA logs, we have to keep that information for a period of 6 years administratively. So if in our counties or in our areas we have these HIPAA logs, you do need to secure those paper HIPAA logs, but we're no longer making entries to those. We're doing all of our work now in the eHIPAA log.
In the past, requests were faxed to Pamela Kendrick for approval. Are we now to scan these into the eHIPAA log for approval?
Yes. I don't want you all to be doing double duty as it relates to this eHIPAA log. This is supposed to be meant to streamline things and help you so that you're not communicating the same information to two different areas. So if you have the ability to scan in those documents that you're receiving and you can put them in the eHIPAA log, we just want you to do it that way. If for some reason your county or your subunit doesn't have the technology to scan the information in and it's just not possible for you to input to the eHIPAA log in that way, those would be the only people who we would expect to actually still be faxing information to Pam in legal.
Requests from other health departments do not require approval. Are these entered into the eHIPAA log or just recorded into the patient CHR?
Okay. They are going to be recorded into the patient CHR, but requests that are going from one health department to the other are going to be for treatment purposes. So that's part of that routine disclosure that we talked about at the very beginning, the treatment, payment, healthcare operations. So if you're communicating from one county to another about a patient, that does not have to be in the eHIPAA log, but it does need to be documented in the patient record.
Okay, this is a question for Sancha. What is a third-party authorization?
A third-party authorization is a written authorization from the patient to the health department to release the patient's records to a third party. An example of a third-party authorization would be a patient that signs an authorization for the health department to release their records to a law firm or to release their records to a family member or to release their records to any other entity. It's a request that we receive from the patient to release the records to someone other than the patient.
Okay. If we receive a request for release of records, but the patient has not been seen in our clinic or has not been seen in the time period requested, can we inform the requesting facility that this is not our patient?
Okay. With that question, it's going to depend. If the individual or the entity that's asking us the question is asking us because they're a physician's office or a healthcare entity that is inquiring for treatment purposes, we can go ahead and let that physician's office know that, hey, we don't have any records on this patient. But if this is some outside group, some third party, whether it be a law firm or any other entity that's requesting records, you need to contact legal for guidance as to how it is that they want to handle that, because we don't want to be giving out people's information by saying they were at the health department and they weren't at the health department. We want to be careful about how we handle those.
Okay. Approval for request for release of records for continuation of care is no longer required. Do we enter these into the eHIPAA log?
The release of records for continuation of care. Well, is this, I'm assuming that this means that it's a physician's office or other healthcare entity that's contacting us to say, hey, we want some records because we're sharing a patient.
Right.
And if that's the case, that's part of the treatment exception, and that won't go in the eHIPAA log.
Okay. If I receive a request for continuation of care that does not have the HIPAA statement, can I release those records?
Okay, let me explain that a little bit. When a physician or a healthcare provider is requesting information from another physician or another healthcare provider to treat a patient, they don't have to follow or have the same type of statements in their release that another entity will have to have. Because one thing that HIPAA wants to make sure that you do is that you're able to treat patients and pay for those services very easily. They don't want to halt anything or hold anything up. So in those cases, you know, if you're giving the information from a patient, if it's a physician requesting information, you'll go ahead and provide them with that information. And there's no obstacles necessarily to jump through for that.
As long as it's for treatment
Right,
purposes.
as long as it's for treatment purposes.
And you don't have to put it on the eHIPAA log.
Correct. You don't have to put that on the eHIPAA log.
Okay. When I receive a request for release of family planning records, what is the correct type of activity or disclosure to choose on the eHIPAA log?
Okay. It's going to depend on who that request is from. So if it's for family planning records and it's from a law firm, I would imagine that that's going to either be through either a subpoena or a third-party authorization, you know, for that particular law firm or that particular individual to get that information. And I think I've had that come up before, and in the drop-down box, you're going to see that third-party authorization is the very last thing in the drop-down box, but like subpoenas are towards the top. So I think people are used to recognizing the things that are at the top of that drop-down box, but if you scroll down, you'll see that third-party authorization listing, and I think that's really the third-party authorizations and the subpoenas are the things that probably come most frequently, in my experience. After that, it would be maybe DHR or something like that, and I think the explanation that you gave as it related to third-party authorizations was a good one, because I think a lot of people have not been familiar with what that really meant, and so I think more people are going to be choosing that because they're going to recognize those.
Last question. What happens when your request is not approved?
Okay.
What happens to the eHIPAA log attachment?
Okay. So you're making an entry, and it's going through the whole process that we've already looked through, and Mino Pam in legal disapproves the request. The way that process works is that chain is broken. That request is completely over. If there were some things that needed to be changed about that authorization or that subpoena in order for us to actually fulfill that request, the process needs to start over. So an example of that would be we get an authorization from an attorney's office. It doesn't have all the required information in it. So Pam looks at it and she disapproves it. And she'll let you know why it was disapproved. And then at that point, that relationship is with that particular entry is over. If that same law firm comes back and they now have an authorization that we can approve, it has all of the required terms, then you're going to enter that in as a new request. You don't go back to the old request. Once something has been approved or denied, it's a divorce of that particular entry, and then you start the next entry over again if you get a group that now has fulfill the requirements that they need to fulfill in order to get the disclosure that they want.
Okay.
Does that make sense?
That's all the questions.
Okay. One more thing I want to talk about was the difference between the CHR3 and the CHR6 as it relates to disclosing information, because this is something that's come up. Recently, in March of this year, we made some changes to the CHR3 that would allow a patient to provide information for someone that they would like their information to be disclosed to. An example of why that was put there in the CHR3 was that if you have a 14 or 15-year-old girl, maybe she's coming to the health, 16, she's coming to the health department for family planning services. Her mom's dropping her off at school, and they need to get her appointment changed from 3 o'clock to 4 o'clock because maybe she's got some kind of practice after school. Well, as many of you all know, if the mom just calls the health department and this 14-year-old, 15, 16-year-old has been coming in on her own for services, the people in our health department are not going to even let the mother know that she's a patient. And so that has become an obstacle because there are instances where people want somebody else to be able to discuss their information. Also, let's say that the kid comes in, maybe they're 17 years old, they come in, they have maybe unusual high cholesterol or high blood pressure. You know, it doesn't have to always be STD or family planning, but whatever information our nurse or social worker gives that person, if they go home and discuss it with their mom or their dad or whoever, and that person has some questions about what the nurse said or what the social worker said or whatever, that parent or whoever they designate will be able to, based on the CHR3, if they're listed on that patient CHR3, they can contact the health department and have a discussion with someone at the health department about what went on during that visit. What I don't want, the place that I don't want there to be confusion is that the CHR3 is just meant for those type of almost casual discussions of a patient's condition. It is not meant as to replace the CHR6. The CHR6 is still the document that we're going to go to when we're looking at disclosing patient records. So I don't want those two things to get confused. So I just wanted to have an opportunity to kind of plug that difference between the CHR3 and the CHR6. Are those? All right. We made it through. So here's the thing. Even though we've provided training on the eHIPAA log and we're going to have these slides available in the document library, we don't expect for you all to be HIPAA experts. I know that's like my favorite thing to do, but I don't expect for you all to understand it completely. So we do want to provide to you all on the next two slides our contact information. Feel free to contact me with any questions that you have related to this training or any other questions related to the eHIPAA log. And please also feel free to contact Sandra Howard in our Office of General Counsel with any questions that you have about authorizations and subpoenas. Thank you for your time today.
Thank you.